Court does call the case of Dale Gretch versus Taylor Adams.
Good morning, Your Honor. Alex Barry Santoro appearing on behalf of Plaintiff Dale Gretch and Dina Davis.
All right, folks, buckle up. This first case is about garnishment. Basically, when wages or assets can be seized to pay a debt. And here's the twist. Defendant didn't even show up. Big mistake.
1545. Nice to see you.
Good seeing you, sir. And this is, I thought, defendant's objections to garnishment?
That's accurate, Your Honor. I did file a writ of garnishment, and there was an objection served after the 14 deadline to effectively stay the garnishment. So I'm here today to
object to any stay of the garnishment. Right?
Yeah, that's a lawyer.
I'm brilliant. I figured that all out on my own.
Yeah.
And they're not here. Taylor Adams, Tiffany Gross.
Do you want me to call the hall or something?
Well, Adams, Gross, the defendant having failed to appear. The motion regarding the objections to the garnishment are denied. Garnishment may proceed. That denial is based not only on the defendant's failure to appear, but also on the merits of their objections.
Thank you, Your Honor. I appreciate your time.
Thank you, sir. Jim Mayen versus Fatima Stevenson.
Fatima Stevenson appearing on behalf of herself. Good morning.
Good morning, Your Honor. Jay McCurgy on behalf of Jim Mayen, E832.
All right. And this is your motion for relief from judgment, ma'am?
That is correct.
All right. What do you want to tell me about it?
Counsel and I originally in late May, I believe, were discussing the option of me purchasing the home that I'm currently renting, because at that time I was made aware that the owner was intending to sell the home. So
notice something: when a defendant doesn't appear, it almost always goes badly for them. Judges don't like wasted time. Question for you guys: should missing court automatically mean you lose, or should there be exceptions?
Responded through email, as you've seen. The property manager, who is also a realtor, and I.
Just like that, the judge denies the objection. No show means game over. This is why showing up is half the battle in court.
I and the realtor I had secured recently have also been in communications as of yesterday. I was just made aware late yesterday afternoon that the property manager, who was in correspondence with my realtor and lender, is not the listing agent. So therefore had no authorization this entire time to work on the deal. And so anyway, long story short, I had not looked for alternate living. I wasn't intending to seek alternate arrangements to move out, because my intention was to actually purchase the property. It wasn't going to be a quick thing, but it was going to take a little time. But as long as I showed progress, and all the relevant parties that were interested were kind of kept in the loop.
Now, here's where things get juicy. This next case isn't just about money. It's about a tenant fighting to stay in her home while navigating what sounds like a messy miscommunication about buying the property. Let's see how this unravels.
To showcase good faith that we could move forward with that and stay the eviction.
Response.
Thank you, Your Honor. The home is not currently for sale. Hasn't been listed yet. My client wants to get the property back.
But, okay, just so that I'm clear, the original conditional order of dismissal was put into place with contemplation of a sale?
That's correct.
No, Your Honor. That is not. Stevenson is representing that we've been in discussion for sale of that home. That is not accurate.
Okay, but was there somebody let me ask this. Whether they had authorization or not, was there somebody operating on plaintiff's behalf that was leading toward a sale?
So there was after the affidavit was sent in late June, Ms. Stevenson sent me this email that she has, I guess, attached to this motion here, that she's been approved for a mortgage.
Okay.
And as you can follow through this email chain here, Essentially, she wanted to put together an offer, and I said, if you're going to do that, you might want to do it quick because we're running out of time here. And that's essentially where that conversation ended on my part.
Right, but there were also other individuals that
The
were.
text messages, Your Honor?
Yeah, well, there are other individuals that are involved that are seeming to indicate that the purchase.
On the plaintiff side, Your Honor, there is a realtor who's the property.
Because as I'm hearing you, the person on the plaintiff side is a realtor, right?
That's correct.
There are, it seems to me, discussions that are going on regarding, well, between the person that's a realtor on the plaintiff side and a realtor on the defendant side.
So the person who's a realtor on the plaintiff side has no agreement.
This is where it gets messy. Realtors stepping into roles they might not actually have authority for, confusing both sides. Viewers, what do you think? Was this tenant genuinely misled, or just buying time to avoid eviction?
To sell the home, there's no.
I get the fact that there may not be some agreement between plaintiff and this person.
Okay, in no way does this person represent the plaintiff or their interests.
In some way they do, don't they?
So, Your Honor, I think the statement that this person is the property manager is incorrect because this person has told me they're not the property manager of the property.
Who are they then?
They helped,
Vis-a-vis the property.
they helped the homeowner purchase this home or find this home as a property for their portfolio.
Say that again?
They helped the homeowner find the home as a property for their portfolio. As an investment property, this property was.
Okay. Okay.
Yeah.
If that's all they are, why are they entering into discussion?
Your Honor, I don't know. If we look through, I have an email from that person in an email chain that both Ms. Stevenson and I were included on from yesterday, and it describes an email between her realtor and this other person describing what.
This other person being whom?
The person's name is Kirk Glassel.
And that's the person that now you're saying is nothing regarding this property.
That's correct, Your Honor.
Then why are they involved in an email chain?
This email, so Ms. Stevenson, I would say, was speaking to a realtor. This realtor reached out to this person they believed to be the real estate agent for this property, although that wasn't the case. And they had a discussion. This email that both Ms. Stevenson and I were.
Close up and no, go ahead.
Yeah, this email that we were both a party to clarifies what that discussion was and that they, what they believe the intent of that discussion was.
If I could clarify one thing, Your Honor. In the email from counsel, it clearly states in the email that I had submitted with a motion for the recommendation was for me to send the offer letter to this individual in particular. And then
This person who now is being claimed to be nothing.
Yep, exactly. That's.
I do have other.
Well, okay, hold on, folks. This may make sense to you. It doesn't make sense to me. Why would she be sending an offer letter to somebody who really has no affiliation to the property?
Oh, I was thinking he would communicate that offer to the home. Should there have been an offer? Because I'm not.
Then right, but is. Okay, Mr. McCurdy, that's part of my problem. Part of my problem is this person and your client may be saying they have nothing to do with the property. Apparently, the defendant believes they do and is operating with some apparent authority. And you yourself also may not know what that position is, but like you said, I'm not a realtor, but this person is doing something. And the very fact that the person is a realtor I think that there certainly is the potential for some confusion regarding that. And I think that's part of my...
I do have more recent communication as of yesterday with the same person.
With who?
With that same realtor, and yeah, and my realtor and the lender.
And the lender?
So, if Your Honor, if
Go
I
ahead.
clarify, I have an email right here between all parties just clarifying what has happened in an email. And the email includes her realtor, this email chain includes an email from
Okay.
her realtor, back and forth. I believe it's relevant.
Okay, but Mr. Mukherjee, the very fact that all of this needs to be clarified, isn't that a problem?
So, Your Honor, after I spoke to Ms. Stevenson yesterday, she made it clear that she was gonna believe that she's been misled here. So I reached out to the realtor to see what was going on. If she hadn't misled, if there was discussions with the loan officer, if there was discussions with a fellow realtor, and what he described to me was something close to what we're talking about here, but not, but missing the target by a little bit. He believes this was a last minute attempt to confuse the situation and stay the eviction. And he clarified that in an email because the realtor who reached out to him had not signed an agreement with Ms. Stevenson. It was just an informal discussion about what, if that property were to be for sale. Now, he clarifies in the email that I have in front of me that he doesn't know where these numbers are coming from, and that he...
What numbers? The offer?
Yeah, correct, Your Honor. Because no discussion had ever occurred about what that listing price would be. No discussion occurred about a wire transfer.
Okay, all right, but counsel, something's going on. I have two realtors on opposite sides, regardless of what their authority is. All right. I have two realtors, and then at some point, according to the defendant in this case, there are communications with a lender. That
The
go ahead.
realtor who may, or the realtor who's standing on the plaintiff's side had no, I don't believe had any communications with the lender for Ms. Stevenson.
Is that right or no?
I have email here with Kirk Classel in communication, several phone call, or a few phone calls, I should say several, with my realtor, and she was relaying information between him to the lender. And there's including the good faith deposit, the amount of that, including something about a back rent, that and all of these other components that would,
Okay. Okay, that's my concern. It may very well be, Mr. Mukherjee, that your client gave no authority for this person to act in this fashion. But what's clear based upon the representations of the court is that they were. And I don't know.
Ms. Stevenson has been putting forth since the conditional dismissal that she was wanting to purchase this home.
Mm-hmm.
After the affidavit went in with the order, I received this email saying, I've been approved for a mortgage. I'm going to try and put together an offer for this home. If any of those things are true, I don't know, Your Honor. Beyond that, no communications until the writ was posted to the door. And then all of a sudden this started as of last Thursday or Friday. If Ms. Stevenson would like additional time, we're happy to accommodate her. We can make any arrangements she finds reasonable. but I don't believe the writ should be overturned.
The problem that I see here is that there's something else that's going on, which, as the defendant has stated, led her to do or not do things. Plaintiff may have a different version that she's coming up at the last minute, doing whatever. Regardless of all of that, I have two realtors. I all of a sudden have a lender involved. I would just say that if Miss Stevenson has gone to those extremes just to delay, it's a lot. I don't think that that's what she did. I don't think the communications that I've seen and the ones that are being described are that. Something, rightly or wrongly, it seems to me, was represented to her regarding the sale of this property. Okay.
Property was never listed. That's
right, but I don't. I hear you, but if you had your, from the plaintiff side, your everyday run-of-the-mill property manager, not a realtor, they're just managing your property, make sure that repairs are done, collect whatever, okay? And she's having discussions with that person, then I might tend to agree that there's not enough there doing anything. This is different because this person's a realtor. And, by the way, I don't think somebody goes up when somebody's a realtor and say, do you have the listing? I mean, I don't know that comes out of anybody's mouth right out of the gate, unless it's the realtor that says that to somebody. You assume that they have the ability to sort of move in the way that they're moving, right? So I get it, but something transpired here that either Miss Stevenson was misled potentially, or something occurred where she just didn't understand it and how the transaction was going to go, or something. I think for your client, Mr. McCurdy, I don't know if she knows what the heck has transpired, because somebody is apparently, well, I'm not making this conclusion, but at least from Ms. Stevenson's perspective, somebody is acting on her behalf or their behalf. And it's just, it seems to me, doing things and making things that may be representations that have to stick to your client. But I don't know. Now, having said that, other problem, Ms. Stevenson, that you have is typically any agreement regarding the sale of property would need to be in writing.
That's
right? But I'm
Huge break for the tenant. No eviction for now. The judge orders a full evidentiary hearing. Translation: we're not done yet. This is basically the legal version of hitting pause on the drama. Would you call this fairness, or just delaying the inevitable?
So there may not have been an agreement, and that may be this court's ultimate conclusion. But I also realize that there are discussions that happen before there's any writing that's put into place. I mean, just in a practical sense. So from what I've seen today, I think it would be improper and prudent on this court's part to issue or to allow the writ to be executed. So at this juncture, the court is going to stay the order of eviction of the writ in this case. I'm going to order an evidentiary hearing on the issue regarding a sale. I will set that for August 11th, and I apologize for pushing it out to that point, but my docket is what my docket is, folks. And I'm going to try to take a vacation, or at least not be here. So August 11th, 2025, I will set that at 2 p.m. Okay, there's a criminal evidentiary hearing ahead of you, and I've got to take care of the criminal matter. But in the interim, I might suggest that the parties try to talk to get straight exactly what's transpiring on the plaintiff side and what may have been said. Ms. Stevenson, you also, and one of the things that you said this morning is that you hadn't had time to make alternative arrangements regarding yourself. So I might suggest that you at least have a plan B, because I don't know what I'm going to rule on this. All right?
I agree.
All right. Thank you, folks.
Thank you, Your Honor.
Thank you.